Special Investigating Unit and Digital Labs Pty Ltd plus 29 others. 1 of 2021, appearing in the Special Tribunal of South Africa before Madam Justice Modiba, 8 March 2022. My lady.
Thank you. Okay, at this stage, only Mr. Roo should have his video on. And subsequently, only the counsel who's addressing should have their video on, as well as their mic. Thank you.
Thank you, my lady. I hope you can hear and see us clearly.
Yes, yes, clearly. Thank
my
you.
Lady, Mr. Curry, Mr. Singh, and I appear on behalf of SIU, the applicant.
Yes. Yes, proceed, Mr. Roo.
My lady, can we proceed with the argument?
Yes, please proceed.
Thank you.
My lady. Sorry to interrupt. My lady, if the counsels may place themselves on record, so just so we know that we have everyone.
Yes,
Thank you.
yes. Thank you for the reminder, Mpho. Counsel for the joining parties, if you could please place yourselves on record.
Milady, I appear for the.
Oh, sorry, carry on.
Milady, I appear for the 32nd, 34th, and 35th respondents. Nicholson, initials WAJ. With me is my instructing attorney, Mr. John Wills.
Thank you.
Yes, as my lady pleases, I appear for the 33rd and 37th proposed respondents, GD Harper, SC.
Thank you.
Milady, I appear for the proposed 36 respondents. My name is Pamenter. For the record, I will spell it PAMMENTER, initial CJ, and I'm from the Durban Bar. I'm instructed by attorneys TL Mbili, attorneys of Durban.
Thank you, Mr. Harper.
May it please you, my lady. Surname is Willis, Johannesburg Bar, my lady, instructed by Tenza Zondi. My lady, I appear for the 17th, 18th, 19th, 26th, and 27th. We don't oppose the applications, but of course we are central to the applications, and we appear before your ladyship today. Your ladyship.
Thank you. Thank you, Mr. Willis.
Thank you, my lady. If I may proceed.
Yes, you may.
Thank you, my lady. The application for Joinder before you, we've all filed heads, and I accept, my lady, that as before that you've read the heads, and it's not necessary to repeat verbatim what's in the heads, but to highlight to you our main points.
Indeed.
Thank you, my lady. My lady, the applicant's case is that as the investigation progressed and they traced more and more of the monies and the destiny of the money, it necessitated the joining of respondents. And up to the point where they then realized that monies went to the, what I will call the Mkhize family, and they of course not parties before the proceedings initially, and that they needed to be parties through the entities which received some of what we say the ill-gotten gains. What is important here is to understand that initially only 4 respondents, the main respondents, were asked to repay the full amount of 150 million. That's the result of what we say unlawful agreements. However, as time progressed, we realized that Mr. Matetwa and his entities were absolutely involved in the what we call an unlawful scheme or the fraudulent scheme, which led to an amendment at the time of the application to include that we also claim from Mr. Matetwa jointly and severally the full amount of 150 million. You would see that, just for your record and case lines, 034-5 paragraph 3 of that notice of motion that now introduced Matetwa not only for the 10.6 million, but for the full amount jointly and severally. The consequence of the further investigations as facts become available was that, and there's a sufficient factual basis in the affidavits on behalf of the SIU, is that money flowed in from Mr. Matetwa also to the joining respondents. And of course, by the very nature, if you want the money back, you must join them as a party. And that's exactly what we were doing. Now, the resistance against the joinder, we're trying to understand it, is of course the one is that the debt has been extinguished, that there is nothing to keep them here because the amount that they received has been repaid. The second one is far more debatable, and sensibly it's an attack on the merits. Now, what we know that at this stage of the proceedings, the merits would be irrelevant unless, of course, if the respondents could make out a case that this joining application is frivolous or vexatious, and that's not the case on paper. So any attack on the merits would be premature. It must be properly debated. And at this point in time, all that we need to do is to say that the parties to be joined, the proposed joining parties, may be affected prejudicially by the judgment of the court, and that it suffices if there exists a possibility of such an interest, and that is that legal interest. It says, and that you would see in our heads of argument, paragraph 7, where we refer to the case of the Johannesburg Society of Advocates versus Ntai, where it specifically says it suffices if there exists a possibility of such an interest. It is not necessary for the court to determine that it in fact exists. In many cases, such a decision could not be made until the parties have been heard. We know that the proposed joining respondents must still file their answering affidavit. There will be a fair evaluation of what they say. There will be replying affidavit, and only then will the merit point be right for hearing. It's premature on case law, it's premature on fact. So the true point then that would remain is, of course, this point that because Mr. Matetwa or Mateta, the entity, his entity repaid 10.6 million, therefore there is nothing to get from the joining respondents because the amount that they received was repaid. Now, is that correct, my lady? If we can get to the history of this matter, as we sit here, we want 150 million from the Mateta group, not 10.6 million. Or initially it was that until we realized the true fact. So what we know is that 10.6 could be given a specific name. It was the alleged income received, that we don't have to go to the merits, but we make out a case to say that was never income received. It is just impossible. He was just part and parcel of the unlawful scheme. Not important for the finding at this stage, but that's the allegation, and it's a fight. That is part and parcel. Now he comes and he repays, and I'll get back to that, 10.6. Now, why would he be absolved? He's not, because he's still in for 140 million, and it's no use and not helpful to say that you can't get double your damages or more than you suffered. That's a sum, that's a calculation that will be made at the end of the case. You see, what have you received, SIU? You have received 30 million, your loss is 150 million, and you only be entitled to the balance that you can show, and it would probably on the basis of a jointly and several liability. But that's at the end of the day when you do the calculation, not in the beginning. You can only say you're part of the scheme, you have to repay, and this is your part that we want from you, or we want everything. Now, we know in the case of Mr. Matetwa that we want him to be jointly and severally liable for the full 150. He's repaid 10, so in his case, it would be 140, and whoever will pay, that calculation will be done at the end of the day to see what's the outstanding damages to be collected. Now, what we fail to understand, why if Mr. Mateta paid back 10.6 million, or Mateta, the entity, I refer to it as collective, as a collective reference. Why would the joining or to be joined respondents get any benefit out of that? Do they say that the 10.6 million is ring-fenced and that's the only claim against Mr. Mateta? Do they say that it's ring-fenced in their case and that whatever Mateta paid, because he paid that amount, that they would get the benefit and they must be released and there's no claim against them? Well, let's look at the law. At the very least, when someone is paying, Mateta comes to the SIU and says, I want to pay 10.6 million. What you then do is to say to the SIU, but listen, I have other respondents that I paid money to out of this 10.6 million. Will you accept this 10.6 million, ring-fence it, and set free the other respondents? Can we do this in a full and final settlement, or what form of agreement that is acceptable to you, and that the consequence would be that the joining respondents will be released from any liability because of the repayment? Where is that, my lady? Where is that agreement? Where did the SIU say to Mr. Mateta, if you repay the money, part and parcel of this repayment of 10.6 million that we accept from you, is that we absolve everyone that receives part of that 10.6, taking part of the unlawful? Where is that? More importantly, where do the joining respondents say we have an agreement, a full and final settlement agreement, or any other type of agreement with the SIU, that if Mr. Mateta repaid 10.6 million, then we release, then we absolve, we fine? It's not there. So how can you walk away in law by someone else making a payment and say you need now to be absolved, that payment settled our liability? It cannot be in law. And that is the main difficulty for the respondents. They haven't filed their answering affidavit to explain their version. They haven't come up with that version to explain why they should be released, but for it of argument. That case, and if it's true and it's not accepted by the SIU, and they say, well, on the papers it must be determined, is that not the probable inference? That's at the end of the day. That's not now, but it's not the case. So it seems ultimately that there's a giant leap between the payment by Mr. Mateta and the notion that they absolved or released because of that payment. Why? There is no allegation support. It does not follow in law. If Mateta paid part, and I want to stress this, part of his obligation to repay of the 150, 10 million, that the effect of that is to release all the people that received money. If I may just give you a little bit of a factual basis of Mr. Matetwa to emphasize the point we're making. Mr. Matetwa, we know, made payments, and we say over and over, he's so part of this scheme with Digital Vibes and Matter and Meta and so on. He received money in Mokakwana events, 8.9 million. says, well, I'm not Mokakwana West, but I agree. It's my, one is the mother, not knowing about that she's in control of the business. The other one is the niece. He says, well, I run the business. The other one received 6.1 million from the proceeds of crime in bevels. He paid to all our trading money. He paid to Sakule farming money. He paid to the Dani Makide money. He paid money to Ghani, the cash money. And the cash money then went in boxes to the Dani Makide. He paid to Composite Trade, that's Mr. Mattis' company money. He paid to Strategy Wiz money, that's Ms. Mita's company. He paid to WT Graphics money, that's Ms. Mattis' company. He paid to Cirella Trading, 3.79 million. That's one of the joining respondents. I may say, by the way, that payment to Cirella was marked as 5 payments, 5 transactions as consultation services. So we don't know what consultation there was. It was not explained why he referred to consultation service. Did he consult with things? Now what the joining respondents do, they say, well, this money he paid to us because we sell cattle and we gave him grazing and farming activities and so on and so on. That is something to be determined, not now, when the matter is ripe for hearing. We don't know. They must still come and tell us, and we will reply and deal with it fully. It's premature to raise that. They need a guillotine point to get past the joinder, not to say, well, on the merits, and the merits are not good. It's not good enough. It's not the time to decide the merits. So what else can they say? Then they come with this elaborate explanation to say, well, by Mr. Saketla, we gave Mr. Matwetwa 10.6 million, and we gave it in the circumstances where we disregarded the grazing fee, just giving money back. We sold cattle for amounts that we cannot reconcile with any commercial terms. Then it's 17,000 per head, then it's 6,000 per head. For some farming facilities, for some farming activities that we don't know what it is. Very wide descriptions of why they gave him the 10.6 million. Even if it's true that Mr. Soketla gave him the 10.6 million, we say you gave him the 10.6 million and the inescapable inferences because you want to stop the investigation. Because part of this digital vibe scheme was to launder money to the McKeesey family. And you want to stop that. You want to be out of that. It must stop now with Mather and Mita and seemingly Matetwa, because I don't know why it's absolved by paying the 10.6 million. It's not. But even accepting that I gave him the 10.6 million, let's say it was for true value, for the moment, why would that absolve them? That's a case between him and Matetwa. If it's a loan agreement, good. Good. If he promised him that he would secure their release, did he? Did he say, I only pay this money to the SIU on condition you don't proceed with the action against the joining respondent? Where's that agreement? He didn't do that. Did they come to us and say, well, we gave the money to Mr. Teta, but please, you can only accept it on the basis that you release us. It is meant to release us from further liability in this matter. It's not there. So what they say then is, against the backdrop that Mateta is liable for 150 million, because he paid 10.6 million and they gave some elaborate payment reasons that are inexplicable and what must be determined later and must be analyzed and says, we gave him 10.6 million and he used that. So what? Why did it release you? We still have our time. If they in possession of ill-gotten gains, they must repay it. They are in possession of ill-gotten gains on all the papers. We say that. We say the money that Mateta paid to you, all ill-gotten, give it back. And the only way, prematurely so, when they can say we want to be released, if there's such an agreement, a full and final payment and so on. There's not. You can't do the merits now. And whether they knew or not know, that's for a later day. Come, file your answering affidavit. But they have not done so. And as we say, it is absolutely out of sync what they're doing. They can, at the appropriate time, file their affidavit, and it must be determined. I'll give one difficulty to explain to you what they have, and to just explain to you what difficulties will present themselves at the full ventilation of the case. We asked for documents, 3512, when they told us that, well, they gave 10.6 million, and it was actually for services rendered or cattle bought back and for some wide description of something on the farm activities. What we don't know, we simply don't know what it is, and forget about the fact, ignore the fact that it doesn't make commercial sense. They tell us, for instance, when you look at Cedar Falls, that's the farm where Dr. May McKeezy, the wife of Dr. McKeezy, is the sole shareholder and the director. They said, no. You have it wrong. In 2011, Mr. Soketla and Mr. Dadani McKeezy entered into this agreement, and it's an agreement with Dr. May McKeezy that we take over the running of the farm, in a company's name, and we're 50-50, and we have a joint venture, and she's really out of it, but in name. Yeah, and they take over the shareholding and everything. And we say, well, we understand why you say it, because an amount of 1.8 million was paid to reduce the liability which Dr. May McKeezy had with Itaba Bank in relation to the bond over the farm of Cedar Falls, and Dr. McKeezy signed as a co-surety. So we say that's another classic example how money was, the ill-gotten gains was siphoned to the McKeezy family. That one is, for example, to reduce the liability of Dr. McKeezy and Dr. May McKeezy. They say, no, you're wrong. It was actually, 2011 already, we took over the shareholding, and we just left the bond in the name of Cedar Falls, not to disturb the arrangements with the bank. That's all. That's all. It doesn't matter. That's our first argument. It doesn't matter, because what was paid into the account, whether it was for the benefit of the joint venture, whether it was for the benefit of Dr. McKeezy, it's irrelevant. It's ill-gotten gain. You can't keep that. It must come back. But they have a further difficulty. I might say, and if you would accept the submission, after, once we've requested the 3512, they did not provide an answer. They have since provided an answer. And in that answer, I may tell you, and they can come and tell us it's wrong because it's their answer. They give a long answer, and then Exhibit DC9, PS9, they deal with this business plan of Cedar Falls. The one, if I may remind you, where they took over the shareholding and the running of the business in 2011. And I want to read to you what's the document that they handed us now, belatedly so. Paragraph 3 of that document under introduction and background. Cedar Falls, and I quote, Cedar Falls Limited, Pty Limited, trading as Essential Equity CC, is a privately owned company which is owned by one shareholder, who is a woman, Now, when was that? We know when that was, that business plan. We get it from page 10, where it says, and the current agronomic condition of the farm coupled with the loan, which has to be serviced, that it is recommended that the items listed below be considered for the current season, 2015 and 2016. So we know the date of this document. It's 2015, 2016 season. So it's not a document before 2011 when they allegedly took over the shareholding and run it through a company. Like, it goes on. So the shareholder is a woman. That's not Mr. Dadani Mkhize, that's not Mr. Soketla. And it then goes on with other detail. Then it says, the farm has employed the services of a full-time farm manager, not of a new shareholder, not of a new company, who manages the agronomics and daily activities of the farm. The shareholder, Dr. N. Mkhize, worked as a doctor for approximately 20 years, and she's currently involved with the planning and financial management of the farm with the assistance of other family members. These are the type of things that they want to avoid by having to file answering affidavits. Because we know now already that explanation is patently false to try and justify the payment in favor or for the benefit of Dr. May Mkhize. It's false. And that's the difficulty if you want to prematurely exit a matter without having to deal with the merits. And as I've said and submitted, my lady, unless they have a guillotine point to say this is taxation, this is frivolous, or there's simply no course of action. You don't say it's part of the ill-gotten gains. You don't say that Mr. Mateta was part of it. You don't say that Mr. Mateta is liable for 150 million and not only 10 million. Then I understand it, but it's not the case. And we say simply that they picked the wrong time, and that the true time to debate this and to argue this would once the matter is ripe for hearing. Thank you, my lady.
Thank you, Mr. Counsel for the proposed joining respondents may address me by order of seniority.
Lady, I think due to my age, I probably enjoy that title. Lady, I've listened to my friend, learned friend, Mr. Roo, and he's also my friend, I might say, with some interest. And I think that I heard him say right at the end that we can only escape being joined, I hope I've quoted him correctly, if there is no cause of action. Now, that has been one of the two grounds on which Cedar Falls opposes this application. There is no cause of action against Cedar Falls shown in the affidavit. And you will recall in my heads of argument, I complained. I said, you're not paying attention to the points that we have raised in our opposing affidavit. You're just fobbing us off. And with the greatest of respect to my learned friends who appear for the SIU, we're still getting this fobbing off. We are, after all, a nation of law. We believe in the rule of law. And you cannot simply drag somebody before a tribunal, such as your one, lady, without having a proper case pleaded against them. Now, in my heads of argument, I took great trouble to quote everything that was alleged against Cedar Falls in the heads of argument, and there's no cause of action there. Simply because somebody pays money to the Atala Bank for the credit of Cedar Falls does not make it, does not mean that there is an obligation by that company to pay that amount of money to either the NDoH or the SIU. The matter is far more complicated than that. In the heads of argument, my learned friends for the SIU tried to rely on the Condictio ob Turpinville in Justam, if I'm getting it right, in Justam Causam. I'll just call that the Condictio, milady. Now that is a Condictio which is available when payments have been made pursuant to an illegal transaction. Now the first starting point is this. The transaction which resulted in the payment of the 1.88 million to Atala Bank, was that an illegal transaction? There's no allegation that is made that it was an illegal transaction. Was the money stolen? Well, it may well be that it was, but even that, I don't say that it was, but even if it was, provided Cedar Falls was an innocent party, that is still a good and valid payment in reduction of Cedar Falls' indebtedness to Atala Bank. And if any authority is needed for that point, it can be found in the case to which I referred in my heads of argument. That's Moore's case. The full reference to that is Absa Bank versus Moore and another, 2017, 1 essay, beginning at page 255, a judgment of the Constitutional Court. What happened in Moore's case was this. The Moores were defrauded in a scheme which resulted in them transferring their property to the fraudsters. The fraudsters then paid money to cancel the existing bond over the property, and then in order to do so, they themselves took out a bond with the same bank. When the fraud became apparent, the Moors went to court and they set aside the transfer of the property. And the issue in before the Constitutional Court was whether they were to get the property back subject to the original mortgage bond or free of the original mortgage bond. And Cameron J. said as follows: this might be a windfall for the Moors, but the position is simply this. They were an innocent party. What happened was the fraudster paid off their debt to the bank, but borrowed money from the bank in order to do so. So the bank now cannot look to the Moors for the payment of the original amount under the mortgage bond. They have to look to the fraudsters. Now that's exactly the situation which we have here. Cedar Falls' account was credited by an amount of 1.88 million by a transaction which the SIU says is tainted because the money itself came from a thief. But what Cameron J.A. said is that even payment by a thief in reduction of an innocent party's indebtedness is good payment of that debt, provided the payee and the creditor, in this case the bank, both acted bona fide. Now there has been no allegation before you, milady, that that Cedar Falls did ever acted other than bona fide. And the SIU can't make that allegation. So on the strength of the allegations which have been made in the papers against Cedar Falls, there's no cause of action. You can't simply join somebody in proceedings such as this, where you can't show that you've got a case. They have to allege facts at this stage, which if proved would entitle them to judgment against, or to entitle them to an order that the payment be made by Cedar Falls to the NDoH. And they simply haven't done that at this stage. with respect, they must do their homework properly. I have a lot of sympathy for the work that the SIU does, and I said as much in the heads of argument, but they must do the job properly. You can't drag somebody into a lengthy hearing, and this one is ultimately going to be, if you don't have a cause of action against them. At very least, it's infringement of Cedar Falls Section 34 of the rights in terms of in the Bill of Rights. Now, milady, there are just a few other points that I want to make, and that is, in their heads of argument, the SIU made much of the fact that they want to join Cedar Falls on the basis that it has an interest in the matter, and that if they fail to do so, they may indeed be hit by a special plea of non-joinder. No, that doesn't arise here. This is not a situation where they're contending that Cedar Falls has a special interest in this matter. What they are trying to do is get an order that Cedar Falls pays money. So this is classically a situation contemplated in Rule 10.3 of the High Court rules, which deals with when defendants may be joined in the same action. In terms of Rule 6(14), that rule is also applicable to applications. So now we have to look at what the test is there to see whether one can join Cedar Falls in these proceedings together with the other respondents. And the position then is as follows. If you'll just bear with me one moment. What has to be shown by the SIU is that that questions arising between the existing respondents and the SIU depend on the termination of substantially the same questions of law or fact which will arise between the SIU and the proposed 36 respondents, Cedar Falls. But if there's no cause of action against Cedar Falls, then manifestly the same questions of law or fact cannot arise. And that is one of the reasons why there has to be a cause of action pleaded. The other is because they're seeking to amend the notice of motion to include a claim against Cedar Falls. And it is now trite law that you cannot introduce an amendment to the pleading if that pleading does not will not reflect a cause of action, if it will be acceptable. The lady then, the learned friend, Mr. Rue, very eloquently has suggested that we must put facts before you to show that we're not responsible for this debt. But that again is just now placing an onus on Cedar Falls, which just simply doesn't exist. You can't make wild allegations and then say to somebody, oh, well, prove that we don't have a cause of action against you. At this stage, we are not, and I want to stress this, we are not concerned with the merits of the matter. I understood my learned friend to suggest that at one stage that we are trying to delve into the merits of the matter. If you look at the affidavit of the proposed 36 respondents, you'll see that astutely we did not go into the merits of the matter because there's no entitlement to go into the merits of the matter at the stage of a joinder. If your joinder opposition is based on a lack of a cause of action, anything that deals with the merits would be struck out of the affidavit. So at this stage, the merits are not relevant. What is relevant are the allegations And the question you have to ask yourself with respect, my lady, is, do the allegations which are made in the papers against the proposed 36th respondent disclose a cause of action? And with respect, they don't. Then I want to deal with this question of the return payment by Mtetra. Now, I'm not here to defend Mtetra or Mtetra projects, but the position is as follows. The case made out by the SIU in the supplementary affidavit was as follows. Mtetra received a payment of 10.6 million rand. From that 10.6 million rand, it paid an amount, I think, of 3.6 million to Cirella. And Cirella then paid 1.88 million rand into the account of it, or to Itala Bank for credit of the account of Cedar Falls. Now, those allegations have to form the basis of the claim against Cedar Falls. There was 10.6 million, which was received by Mtetra, and that money went, a portion of that money went to Itala Bank. Well, that 10.6 million has been repaid. The fact that there may well be additional liability on the part of Mtetra has got nothing to do with the case against Cedar Falls. The case against Cedar Falls, insofar as it is a case, is that the 1.88 million that was paid to Itala Bank for the credit of your account came from the 10.6 million rand which Mtetra received from Digital Vibes. So at that level, if that 10.6 million is repaid, at very least, then there is no cause of action against Cedar Falls, because there has been no prejudice suffered by the NDoH, and I stress this, at the expense of Cedar Falls. Milady, I also want to touch on reliance on section 172(1)(b) of the Constitution, and I have to start by acknowledging that where in the heads of argument I questioned whether this tribunal has the power to make an order, I was not aware of the fact that Milady had already made, in a previous matter, handed down a judgment where you very carefully went into the matter and you determined that you do indeed have that power. I'm very obliged to my colleague, Mr. Nicholson, for drawing that to my attention. So I withdraw that that submission in the heads of argument. I'm certainly not going to waste everybody's time by trying to persuade you to change your mind. So that's a dead issue. But there's still the other point which I make. You can't simply say that there is a claim under section 712(1)(b). The question is, what is that claim? How does it fall under section 172? You can't just read section 172(1)(b) on its own. It's got to be read in its context, which includes section 172(1)(a). What is the constitutional issue they rely on? Why haven't they pleaded that? Why is it alleged that our conduct is contrary to the Constitution? Then on what basis do they contend that it's just and equitable that this money, which went into Itala Bank, should be repaid by Cedar Falls? Now, that's not just a spurious matter. I mean, what would happen now if, Milady, this tribunal was ultimately to make an order that Cedar Falls repays the money? They would then have to find 1.88 million rand and presumably interest on that as well. And then they would have to go to Tyler Bank and say, listen, that 1.88 million was paid to the credit of our account. It shouldn't have been paid to the credit of our account. So please give it to us so that we can pay it back. And what's the Tyler Bank going to say? No, sorry, not going to do that. Now, that's, that just highlights how ill-founded the claim of the SIU against Cedar Falls is, because you could then have a situation where it's contended that it's just and equitable that Cedar Falls has to find 1.88 million rand to pay, but it may not be able to get that money back from anybody. Then, milady, there are other points which I've raised in my heads of argument about the fact that any possible case in this matter was made out in the heads of argument only and not on the affidavits. I don't abandon that point. I don't abandon any of the other points, but those are the main points which I seek to make. I don't know if my lady has any questions you want to address to me.
Mr. I'm concerned about the approach you take in determining the case against Cedar Falls as pleaded. Yes. And you seem to limit yourself to the paragraphs that you've quoted in your heads of argument.
Yes.
Without regard to the full case that the SIU seeks to join Cedar Falls to, as pleaded in the review.
Milady, I have been through all the affidavits in this matter, but I went carefully through the affidavit, the supplementary affidavit, and I did it again over the weekend before this hearing. You will see that a case is made out there that a considerable sum of money was stolen by Digital Vibes, that Digital Vibes then distributed this money in some very strange ways to different people. But as regards Cedar Falls, all you will see against Cedar Falls is this, that the sole director happens to be the wife of the erstwhile Minister of Health. And there are allegations that he and his son and others have benefited from this theft of the 150 million rand from the NDoH. But what you will not see in those papers, with respect, my lady, is anything that points a finger at Cedar Falls or its sole director. Now, yes, Cedar Falls, at the end of all this, is in a position where its account with Tyler Bank has been credited with 1.88 million rand. But as I've suggested in the heads of argument and also in the affidavit, if there is a cause of action, look to Tyler Bank and then leave it to Tyler Bank and Cedar Falls to solve.
The second issue that that concerns me from your case is that you don't seem to have considered the wide discretionary corrective powers that the tribunal enjoys in terms of Section 1721B of the Constitution.
Yes.
To remedy the loss the state stands to suffer as a result of the impugned contract between Digital Vibes.
Lady, sorry, I do apologize. Please finish.
Did you hear me?
Yes,
I'm now
yes,
done.
sorry.
You can deal with what I've put to you.
Yes. Okay, if I may just deal with that, then is this. Yes, I've had to concede that you do have power in terms of Section 172 bracket 1 bracket B, but it's got to be just and equitable relief. Now, in what is expected of the SIU is then to make out a case for just and equitable relief, but it hasn't done so. In its papers, it did not even mention section 1, and this is now in the affidavits, it did not even mention section 172 bracket 1 bracket B. It mentioned that a relief in its heads of argument. Now, it must properly plead a case against Cedar Falls. Then at that stage, then we can start talking about just and equitable relief, but it hasn't even started. Lady, I do not understand that section 172 bracket 1 bracket B creates a whole new self-standing cause of action in law. Because bear in mind now that section 172 bracket 1 bracket A empowers a court to declare any conduct which is contrary to the Constitution to be unlawful. And if it does, then section 172 bracket 1 bracket B comes into play, where an order has to be made that is just and equitable. But before we get there has to be a case made out that what Cedar Falls did was unconstitutional. And that has not been shown. And again, I simply go back and I rely on Moore's case. Moore's case is very important in the context of this matter, my lady.
Mr. Helmut, Moore case was in Moore.
Mm-hmm.
The facts of that case were entirely different. The court there was not dealing with a government procurement contract.
Mm-hmm.
So section 172(1)A was actually not applicable. In the context of government procurement contracts where that section is applicable, the Constitutional Court in Steenkamp has made the powers of the court very clear that the court has very wide, in fact, a new cause of action is articulated there, that the court has very wide powers to correct the unlawfulness that has resulted from an impugned contract.
Yes, and the position has also been dealt with more recently in Badika's case, the judgment of Taronjay. But can I just draw...
Which case is that?
That's Badika, B-A-E-D-I-C-A.
Versus...
Sorry.
Badika, okay.
And I also touch on Buffalo municipality as well. But, milady, are we not there dealing with issues which arise inter partes? In Buffalo municipality, the issue there was that the contractor who had done work under an unlawful contract was allowed to retain what had been paid because they were an innocent party. Now, in this case, one cannot simply assume that Cedar Falls or its sole director, Dr. Mayim Keys, are anything other than an innocent party. How far can one now go and chase up this money?
But not all those issues stand to be determined in the review. The Constitutional Court has said in all pay, the innocence of a party is actually an irrelevant consideration when determining just and equitable relief.
Yes, look, one accepts that because if something is unlawful, whether you're innocent or not, is not of relevance to whether or not the transaction is to be set aside in terms of section 172(1)A, but it is highly relevant in terms of section 172(1)B, just and equitable. But at this stage, we are delving headlong into the merits of the case. And my point is this, my lady, that what is needed to be done in this case is a proper pleading of the case against Cedar Falls so that it knows in advance what case it has to meet. That's only part and parcel of fair procedures, which is guaranteed by Section 34 of the Constitution. At this stage, my lady, we don't look at the merits. We look at what has been pleaded, and we ask ourselves if everything that has been pleaded against Cedar Falls is proved to be correct, is there a triable issue? And that's my argument, there isn't. What they're seeking to do, what the SIU is seeking to do, is to cast the net as wide as possible in the hope that eventually something will come out. That's not fair procedure.
Thank you, Mr. Palmer.
Thank you very much indeed, my lady.
As it pleases, my lady, I think I'm next in line.
Yes, Mr. Harper.
Yes, thank you, my lady. My lady, before I delve into the complexities, I'd like to deal with two fundamental matters. Firstly, policy issues as far as they involve the SIU and its pursuit. And secondly, what I term, let's get back to basics, so we know what the case is actually all about. So dealing with the first point, in our respectful submission, it's unquestionable that the SIU's efforts are generally commendable. The pursuit of monies that are stolen from the state is something that is commendable. One seeks to regain ill-gotten gains from corruption, etc., etc., and the money should be spent on where it should have been spent in the first place, according to government policy, not given to fraudsters. There can be no question about that. And we have no criticism of the SIU in their pursuit in that regard. But the danger, my lady, is this, is that the SIU must be reined in if it becomes overzealous. And this is what we say this case is about. The SIU is making wholly unsubstantiated allegations based on inference and speculation. And I join with my learned friend, Mr. Pameter, in classifying them as wild allegations in certain respects. So they make these wild allegations, and they make them in relation to a cause of action that they have not relied upon for present purposes. And I'll get to that to explain that. So the question from a policy perspective, an overall perspective, is why should the SIU be reined in if it becomes overzealous? Well, the answer is not far to seek. Firstly, because innocent parties are dragged into a dispute. There is huge reputational damage to my clients in particular that they are very, very concerned about, and which drives a lot of their opposition to the joinder. And secondly, they suffer huge financial prejudice because the resources of the state are basically fairly unlimited in these types of matters, whereas those of private individuals are not. So they get caught in the snare of entanglement in a very big case where they should not have been involved in the first place. The second reason why it's desirable to rein in the SIU if it becomes overzealous is that it's prejudicial to their own pursuit of justice. There's no point in involving a whole lot of additional parties if you don't have a cause of action against them in the first place. That's just going to overly complicate the matter. It will ratchet up the legal costs, and no one wins at the end of the day except perhaps the lawyers involved. So that's the policy aspect. The second aspect is, let's get back to basics. What is this case about? We know that it's a case launched by the SIU for a review and the setting aside of an impugned contract between a government department and Digital Vibes. So far, so good. That's got nothing to do with my clients or anyone else. And somewhat unusually in our experience, the SIU then coupled the review application with an application for money judgments against persons, including now they want to seek to join my clients, Tuso Kushle and Serela, for the purposes of those money judgments. We're not saying that it's incompetent to couple a review application with a money judgment. It is possible in circumstances, but it's unusual. And the fact is that one must still examine the basics. The basics are as follows. My clients, Tuso Kushle and Serela, are not alleged to be a party to the impugned contract at all. It's got nothing to do with them. The whole review proceedings have nothing whatsoever to do with my clients. What has to deal with my clients is the money judgments that are sought against them, which are bundled into the review application. Now, that's what I want to focus on. If you apply for a money judgment on papers, in application papers, you cannot do that for an illiquid claim. You cannot do it for a damages claim. In other words, if the SIU alleges that my clients are somehow co-conspirators or fraudsters, they would be perfectly entitled to sue my clients in an action for damages arising out of fraudulent misrepresentation and as being co-conspirators. They have not done so. They have not made out that case in the present papers against my client. So with respect, the learned friend for SIU's address is largely irrelevant as far as their cause of action is concerned against my client. They plead no allegation of fraud against my client, and they do not claim damages for fraud against my client. Their claim expressly disavows a vindicatory action. Their claim is expressly limited to just two things. One is the condictio obturpum causam, and the other is the constitutional powers under the section of the Constitution relied upon by them. Now, at this level, which is an application for an amendment, as correctly pointed out by my learned friend, Mr. Paminter, and an application for joinder, the test is whether there is a cause of action. If there is no cause of action, then cadet quaestio, that is the end of the matter, because you cannot ask for an amendment if you don't have a cause of action set out in the amendment. In other words, if the amendment is acceptable, your claim for the amendment and your claim for the consequent joinder must fail on all the accepted tests. So that, coupled with the principle that affidavits are a combination of pleadings and evidence, mean that their case must be pleaded and there must be evidence in respect of the two causes of action relied upon. As we say, if they don't have that, if it's acceptable, then there should be no joinder. It's not a question of going into the merits. It's a question of whether on the SIU's own allegations they have a cause of action. And that's the basis on which we claim that their cause of action is acceptable as pleaded. So the starting point in relation to the condictio condictio obturpum causam are certain basic facts as well. The remedy is a subset of the enrichment claims, and the authorities make the point, in particular Perry's case makes the point that if there is no cause of action, then you have a claim under the sine causa, and if you have a no cause of action, but there was a mistaken belief that there was an obligation to pay, then you have a claim under the condictio in debiti. The SIU's claims are on not either of those two. Instead, they rely upon the condictio obturpum causam. And according to Perry's case, that exists where there is a cause of action, but the cause of action is unlawful and illegal. So the question is, what is the cause of action that gives rise to the condictio obturpum causam? And the answer is that it's the impugned contract. That's what they're relying on. My clients were never a party to that. It's got nothing to do with them. So where you have immediate parties, for example, if you're talking about a contractual situation, the parties to the contract, there is a cause of action between them. That's the contract, but it's illegal. Let's accept that for present purposes. We're not conceding that. We don't know the situation. So that would enable the SIU to recover an unjust enrichment from the other party to the contract, which is Digital Vibes. That's as far as it goes within a contractual milieu, within a contractual regime. Perry's case had to deal with a forged check. And Perry's case is not free from criticism, but the parties there were immediate parties, that they were the banks who had actually received the proceeds of the check. In that particular case, Mr. Dunbar's bank and his trust bank. So one can understand the application of the condictio ob terpem causam in those circumstances. But the basic principle remains is that where you have money that passes from one person to another, and in particular to a bank, the moment the money loses its identity, it becomes untraceable. You can't go further than that. And the principle of commixtio operates. Now, there is an exception to the principle of commixtio, and that is where the money is held in an identifiable fund of money. And if one looks at paragraph 18 of the Perry judgment, one can see that the facts there were that the monies were still in an identifiable fund of money, a ring-marked or earmarked fund of monies, and therefore they were traceable. That's not the situation at all. With respect, the facts of this case are a million miles away from that. The money was paid from the government's bank to Digital Vibes Bank. It then became wholly mixed up with the rest of the bank's money and lost its separate identity. It was never held in a separate fund. And then the money apparently was paid from Digital Vibes Bank to Matetwa, and that in fact went to Matetwa's bank. And there again, it was mixed up with that bank's monies. And then eventually it gets down the line to Cirella's bank, and again it's mixed up there in monies. And after that to Tuso Kushle's bank, and again it's mixed up with monies. It's a hopeless case, quite frankly, to attempt to trace that money and say that the money that eventually landed up in the hands of Tuso Kushle and Cirella was the stolen money. It wasn't. It was some other bank's money, and the bank had long since lost its identity. The case on condictio ob terpem causa is a complete non-starter. It's dead in the water with respect. There is no cause of action whatsoever based on that condictio. And that, we say, with respect, should be the end of the matter. And we've given all the references to the decided cases. In particular, the case of Whitehead versus Dumas makes it very clear that you have to look at the causa that's involved. And the causa in this particular case, as we've said, is the impugned contract which they seek to review. It's nothing else. The monies that were obtained from Matetwa's bank to Cirella rested on a completely different causa. And the monies that were paid from Cirella to Tuso Kushla, again, was a completely different causa, and it's been set out in the papers. It's got nothing whatsoever to do with the condictio ob terpem causam. The condictio ob terpem causam, to sum up, is not a remedy to trace monies that are not held in an identifiable fund. It does not act as an antidote to the principle of commixtio. It's not a way around it. Now, the only other basis that SIU rely upon is the section of the Constitution. On our understanding, that section does not give a general cause of action where none exists in law. It applies where you've got a cause of action in the first place, and you can then ameliorate the effects of that cause of action on the particular contract in question, if we're talking about a contractual situation like we have here. So it has no application in the present circumstances because there is no cause of action to begin with. And one can't magically say with respect that because a contract is set aside on review and the court has constitutional powers to ameliorate its finding, if it sets aside the contract, that this means that third parties down the line can be dragged in and held liable on some amorphous general cause of action that no one has ever heard of in South African law ever before, and they can somehow be held liable for it. quite apart from that, my learned friend Mr. Pamata is perfectly correct in saying that it was never pleaded. And we go back to the situation where an affidavit is a combination of pleadings and evidence. If there's no pleading, there's no case, and there's no pleading that relies upon this constitutional point. And it's raised for the first time in heads of argument as with respect to desperate afterthought to try and counteract the fact that with respect, SIU knows that it does not have an action under the condictio obturpum causa, because it's simply inapplicable in the present circumstances. So we come back to the first point I made. With respect, SIU is being overzealous here, and it's counterproductive to their own noble efforts to recover monies. It's not in anybody's interest to add in these innocent third parties of Tuso Kushla and Sereda in circumstances where there's no cause of action made against them at all. Now, our learned friend, Mr. Roo, has a lot to say about a cause of action that has never been pleaded. And that is the cause of action for present purposes. That is the cause of action against Matetwa, because he says, oh, don't worry about the fact that the money's actually been repaid. Matetwa owes us the balance of the 150 million. Now, that claim can also only lie in delict for damages if they can allege that Matetwa was a co-conspirator. And that cause of action has never been pleaded in present circumstances. As we say, if SIU want to sue Matetwa in an action for damages, then they're welcome to do so. And if they want to sue my clients, Tuso Kushla and Cirella, in an action for damages, if they want to be so bold, and they have to be very careful in alleging fraud that there is a reasonable basis, then they can do so. But we say that there is nothing in the present case that gives rise to a delictual claim based on fraudulent misrepresentation for the balance of the 150 million. Now, our learned friend, Mr. Roo, attempts to turn around the situation. He says, oh, but you haven't said that the 10 million odd that was paid was in a ring-fenced account. That's a total inversion of the correct situation. In order for SIU to proceed and to succeed in the first place in respect of that money, they would have to show that it was held in an identifiable ring-fenced account all the way from Digital Vibes to where they got to Tuso Kushla and Sereda. And they haven't begun to do that. They haven't even made the allegation. So it's no answer for them to turn it around and say, oh, well, you haven't said that the money that was repaid came from an identifiable fund. With respect, it's reverse logic and circular and cannot succeed. Yes, I've heard Milady's questions to my learned friend in relation to Steenkamp. If I can just add this, on our understanding of Steenkamp, it doesn't go so far as to say that there's a general or universal equitable case against third parties based on just and equitable. In other words, it doesn't give the power to the court to say, an individual court, I think that it's just and equitable in the present circumstances for there to be a cause of action. It doesn't say that at all on our recollection of it. And it would be a very startling thing if the court were actually to say that, because it would mean that anyone could basically rely upon that section the moment one is talking about setting aside government contracts, and give the government an undemarcated, unparticularized general cause of action based on what the individual judge considers may be equitable in the circumstances. And what may be equitable to one person may appear to be inequitable to another. So there's no general jurisdiction and no new cause of action, we say, based on just and equitable. We've quoted the decision, the recent decision in our heads of argument about Brightwater, if it serves me correctly, my memory. I can just get to that. Brightwater, yes, it's the BW Brightwater Way Props Pty Limited versus Eastern Cape Development Corporation, and it's a 2021 Supreme Court of Appeal decision. And what their lordships say is that Section 172(1)(b) of the Constitution empowers the court when deciding a matter to make any order which it deems just and equitable with reference to the circumstances of a particular matter. And then they say this, quote, "This simply means that the effect of a declaration of invalidity may be ameliorated by the court in the exercise of its just and equitable discretion at the remedy stage." That's all they're saying. They're just saying that if you decide that the contract must be set aside, then you can ameliorate the effect of that. It doesn't say that you have a general power to have a new cause of action against persons down the line who are not parties to the contract at all, and it doesn't say that there's a new cause of action created. Now, Judge, with respect, if I'm wrong, then the question has to be answered this way. Where does this stop? Does it end up with the literally the metaphorical, the butcher, the baker, and the candlestick maker? Because if the SIU is correct in what we classify as their overzealousness, then they can go to the persons, for example, the employees of Tusokushla, and say, well, you received stolen money because you were paid with money that was paid into Tusokushla, and now you must give it back. They could go to Checkers if some of those employees paid some of that money to Checkers and say to Checkers, well, you must give the money back. The question is, where does it stop? And the authorities make it quite clear that it's the immediate parties to the particular transaction, whether it's a contract or a forged check or something like that. If you can say the money is still there in an identifiable fund, then you can get it back from that particular bank.
Mr. Harper, in this instance, the SIU is clearly not pursuing the butcher, the baker, and the candlestick maker. It's very clear from their case that some of the monies has been spent in that manner. What they are pursuing here are parties associated to Minister Mkhize's family as well as the related entities. Now, the question of just and equitable remedy as a discretionary power in terms of Section 172(1)(b) is one clearly determined on the facts of each case. So the concern that you raise, that what is just and equitable to one judge may not be to the other, should not concern you, because in each case, the judge is required not to exercise that discretion capriciously or on irrelevant facts or principles. It must apply its mind to the circumstances of each case.
Yes, we appreciate that, Judge. We agree with respect to 100%, but with respect, it begs the question about whether there's a general universal action to recover money afforded by that section of the Constitution. And whilst the judge can exercise the discretion to ameliorate the effects of a declaration of invalidity, there's no doubt about that, it doesn't mean that the judge has the power to order persons to pay where there's no cause of action. And the second answer to the question you posed to me is this, is there are what we've termed to be wild allegations as regards who's associated with the Mkhize family. They have nothing to do with the present circumstances whatsoever, because we go back to what the cause of action is that is relied upon for present purposes, and we know it's only the condictio obturpum causum. We know it's not the vindicatory action. We know that it's not delict. And that's why I keep on saying, if they say that, if they want to be so bold as to sue my clients and say that they are liable and delict because they're parties to the fraud, then they must do so at their own peril. But that would be an action. It's incompetent in the present proceedings to have a claim for damages on application. The authorities are crystal clear that you have to go by way of an action. And moreover, that's their first difficulty. The second difficulty is that they make no cause of action based on fraud or association with the Mkhize family in the present circumstances. So it can't, with respect, be slipped in the back door whereas Section 172 of the Constitution, which has nothing to do with creating a new cause of action, they suddenly say, oh, well, we may have a cause of action because they were associated with the Mkhize family. It's not the law. It's a very dangerous precedent with respect to say that there's a general universal action given by that section where no cause of action actually exists. The authorities are very clear that it enables one to ameliorate the position where there is an existing cause of action, where there is a declaration of invalidity. It nowhere extends to causing or granting a judgment against persons who are third parties to the impugned transaction. Our clients are never alleged to be parties to this contract that they seek to review. So it is with respect to the butcher, the baker, and the candlestick maker. It's exactly the same.
They are indeed not party to the impugned contract, but they are alleged to have benefited from the benefits that flow from that contract, and hence they are being pursued.
Well, I suppose Checkers would also have benefited because the money that was obtained originally was spent at Checkers. Our clients have said there were legitimate cattle transactions involved. There was a legitimate grazing agreement. We have put up the documents in response to 3512, but we say that all of that inquiry is irrelevant in the first place because you have to look at the particular causa. What is the causa against our clients? That's what we keep on asking. And every answer we turn up to comes back to two things. One is condictio ob terpem causam, which they don't have. And the other is this general power under Section 172, which has never been pleaded. We've never had the opportunity of dealing with an affidavit and doesn't exist on the authorities. And as we say, if they want to make these wild, far-reaching allegations, then they must sue us in an action for damages. It's not the same as saying that we've got the money that is traceable. The money is not traceable. We haven't benefited from these transactions. My clients have benefited from the separate contracts, entirely different causa that they had with the Matetwa and the other persons alleged in the papers. There's nothing whatsoever to do with the impugned contract in question. It's a completely different set of contracts. And significantly, the SIU do not in these proceedings attempt to set aside the contracts to which my clients were a party. There's no cause of action, no notice of motion saying they want to set those aside as illegal. So on the present fact, those contracts stand, and it's a completely different causa. What they can't say legitimately with respect that my clients have benefited from the transactions. The fact that one company gets money from this source and from another source and then enters into a contract with my client doesn't mean that my client has benefited from the money in relation to the separate contract which gave rise to the source of the monies. It just doesn't follow as a matter of logic or of law. So we come back to the situation where, with respect, we say that the SIU's case against Thuso Kushla as pleaded and its case against Cirella as pleaded is hopeless. There's no point in dragging them in here, and it's going to be prejudicial to them, and it's going to be prejudicial to the SIU. They must be reined in with respect in their overzealousness. So those are our submissions, my lady. I don't know if there are any further queries that arise. We say with respect that the application for joinder should be dismissed with costs, including the costs of senior counsel.
Thank you, Mr. Harper.
My lady, I appear for the 32nd, 34th, and 35th respondents. I do see that it's past a short adjournment. There's
Yes, I think we should take the adjournment at this point. I wasn't keeping an eye on the time. Thank you, Mr. Nichols. It's now 26 past. Let's return at 20 to 12.
Indeed, my lady.
Thank you. We adjourn.
Just three preliminary issues that I think needs to be raised. The issue of the condonation application for the 32nd, 34th, and 35th respondents answering affidavit. My learned friend, Mr. Roo, indicated in his heads of argument he's no longer opposing it. So my submission is that the application did make out a case, and a condonation should duly be granted. With regard to the joinder of the 34th respondent, in the heads of argument, similarly, Mr. Roo, in his heads of arguments, stated that joinder of the 34th respondents may no longer be necessary if the applicant confirms that the monies were for the benefit of the 35th respondents. In our heads of argument, we confirm that, so it may no longer be necessary to join the 34th respondent. The final issue is, in addition to the arguments that will be raised here, the arguments of the 33rd, 37th, and 36th respondents, we fully endorse those arguments. Milady, the applicant seeks a joinder of the 32nd, 34th, and 35th respondents to the main application with the view of recovering 1,090,000 rand and 650,098 rand. Now, it is common cause that this is the value of the impugned contract between the National Department of Health and Digital Vibes, which is 150 million. The applicant also seeks to recover 150 million and no more, because that is the value of the impugned contract. Now, it is further common cause that the 32nd, 34th, and 35th respondents received these monies I referred to earlier from Mateta projects, who between Mateta and Mr. Mtetwa received a total of 11,542,784 cents. It is further common cause that full amount has been repaid. Now, so our very crisp argument is that the monies have been repaid, and therefore there is no longer there is no cause of action. Mr. Roo, in his argument, he appears to say that, well, that's not the end of it, because in this joinder application, what we seek is also that Mr. Mtetwa be joined several and liable for the full 150 million. Now, that may be so, but that has got nothing to do with the respondents that I represent here. And the reason for that is that they received the monies from Mateta and not from Mtetwa. So Mr. Mtetwa is now joined 150 million, joined at several liabilities for the full 150 million, but Mtetwa is the one where the money emanates from, and Mateta, the company, has not been joined at several liability. So which would mean, if the applicant is successful and ultimately gets all the relief it asks for, it will receive more than 150 million and not 150 million. Now the question may be, can that be done? Our submission is no, that should not be done and that cannot be done. Now another issue, and it's quite a concerning issue, is that Mr. Roo also in his argument stated that these joining respondents benefited at the expense of the former minister and his family. The problem with that submission is that the former minister is not part of these proceedings, and the former minister has not been pleaded that is the cause of action. The cause of action starts with the former minister and then to his family. So the issue, the problem, if that view has to be endorsed without a proper pleading, without the former minister being part of this Joinder application, what it would mean is that, I recall the judgments of Judge Nicholson in one of the Zuma judgments, where the SCA criticized him and said that the judgment went on not only to red card the players, but also red carded the spectators. And that may be the problem here. If the premise on which the joining respondents are being joined is the former minister without that being pleaded, and therefore the former minister not being part of these proceedings. Now, Milady, as I've indicated, the question is, may recovery be for the losses? May the recovery be for an amount in excess of the 150 million? My submission is it can't be. And an authority for that, if we look at the empowering proclamation, the empowering proclamation, R23 of 2020, states in its preamble, inter alia, to recover any losses suffered by the state institutions of the state. Losses. So my submission is that this tribunal is limited in its just and equitable award to the losses, not anything more. That view, my lady, has been endorsed, my submission, by a ladyship in the Special Investigation Unit vs. MEC for Department of Treasury. The full citation is in our heads of argument, where a ladyship said at paragraph 92, the relief must fit the injury. My lady, the relief must be fair to those affected by it and yet vindicate effectively the right violated. My lady, if I can just say there as well, perusal of the judgments of the Special Tribunal, I've perused, I've went on to Safri and I've perused all the judgments. There does not seem to be any view endorsing the recovery of an amount higher than the contract in none of the judgments of this tribunal. In fact, in all pay, consolidated, limited, the 2014, the one at the Constitutional Court, at paragraph 30, the court says, logic, general principle, the Constitution, and the binding authority of this court all point to a default position that requires the consequences of invalidity to be corrected or reversed where they can no longer be prevented. So, my lady, it appears that even the Constitutional Court endorses the view that the losses recoverable is the value of the contract. And as I've demonstrated, the fact that this money comes from the joining respondents receive this money from Mateta and not from Mr. Mtetwa would mean that an amount greater than 150 million would be recovered. My lady, then we go on to the Malan Friends case that he quotes for the Joinder, for the test for Joinder, the Johannesburg Society of Advocates vs. Nate. My lady, what that case says is that the parties must be substantially affected. The interests of the parties must be substantially affected by the judgment. Now, there is no cause of action as has been demonstrated. It hasn't been pleaded in the supplementary affidavits. We have not taken the view to answer to the issues of the condictio in our reply here, because our view is that's not a pleading. So therefore, it is unnecessary to answer to something that has been pleaded in the heads of argument. The law is tighter on that. So because there's no cause of action, there can be no judgment issued that would be prejudicial to the joining respondents. My lady, the issue of proceeds of crime, my learned friend, Mr. Rue, for the applicant, in his heads of argument, and I think he speaks about it a bit in his in the replying affidavit, speaks about the proceeds of crime. Lady, the empowering legislation for the proceeds of crime is the Organized Crime Act 121 of 1998. Section 18(2)(a) of the Act specifically says that recoveries shall not exceed the value of the defendant's proceeds of the offense. So, my lady, even if we were looking at poker, we still would not, a ladyship would still not be able to give an award that is more than the contract value. My lady, we deal with it. I think we deal with it in the heads. The issue of this amount and the amount not paid by the 18th respondent are not being paid unconditionally. My lady, my submission is it's quite simply, there's nothing controversial about that. There's nothing extraordinary about that. A ladyship has to make the finding that the impugned contract was unlawful. After making that finding that the impugned contract was unlawful, a ladyship then has to determine what a just and equitable remedy may be. The just and equitable remedy may be a repayment of the balance received after the department received value. And it's from that balance that the 18th respondent said, well, if I did give value, I would like that to be paid back. So there's nothing uncontroversial about that. And it also does not mean that whatever value that is recovered from the 18th respondents, a ladyship must now look to the joining respondents for that money. Lady, those are my submissions. I haven't went through the full heads of argument, but these are just some of the points that I would like a ladyship to highlight. Unless a ladyship has any further questions.
Thank you, Mr. Nicholson. Thank you.
Thank you.
May it please your ladyship. My lady, as indicated earlier, I appear for Mr. Mtetwa, and the party is related to him, my lady, and I've listened with interest to the submissions. And with your ladyship's leave, I would just like to make 4 submissions to your ladyship in relation to what we've listened to, because they directly impact on our client or clients at 17, 18, 19, 26, and 27. And at the center of that, of course, is Mr. Welcome Mtetwa, and then these other instances of which one of which is Mteta, the company. So if your ladyship would permit me, I'd like to do so.
Yes, you may proceed, Mr.
Thank you, my lady. My lady, in essence, what your lady has placed before you in this tribunal is a review, as you've heard, in relation to a specific contract. And You've heard the submissions, which we obviously must align. I must align myself and my clients with because they are correct. More particularly, milady, that the contractio relied on is stillborn. Stillborn because, simply put, there's nothing identifiable, and Mr. Hopper has made submissions to you in relation to commixture, which I don't need to take any further. Milady, Mr. Rue made a submission to you, and maybe it was just vernacular at the time, I don't know, but I must, with the greatest of respect to him, correct it on a factual level, and there's no such thing as the Mateta group or the Matetwa group. There's only one Matetwa, that's Mr. Welcome Mdu Matetwa, the 26th respondent, and there's only one Mateta company, and that is the 18th respondent. There is no Mateta group, and there's certainly no Matetwa group. Never pleaded, never relied on. The amendment, milady, seeks now to make Mr. Mtetwa jointly and severably liable. Mr. Nicholson correctly pointed that out to you. Milady, if you go to the applicant's heads of argument, page 18 and paragraph 28 thereof, well, it's made clear. And in fact, the other counsel have referred you to this fact, and the correct fact is that it is Mr. Mtetwa against whom the amendment is made for joint and several liability. That automatically disconnects all the parties represented by the other counsel this morning. Milady, why is that important to us? Well, milady, firstly, the SIU's information was garnered from our client, Mr. Mtetwa. They don't have a version beyond his version, and he'll put his version up and pursue that version in due course. That's the first point, and as Mr. Harper correctly pointed out, it doesn't serve the interests of justice, the interests of the SIU, or the interests of any other party to overcomplicate a matter such as this. Mr. Harper referred to the endless resources of the state, and that not being the case of an individual. That is very precisely the situation our client, Mr. Mtetwa, and other clients we have, but in particular him, find himself in. And indeed, he's properly before this tribunal. We don't take issue with that. He's properly cited, and we're not taking issue with that. But, milady, it doesn't serve his interests to have other parties join to the proceedings, which are going to complicate these proceedings way beyond his own resources, to ultimately defend himself as he's entitled to do. And that is why your lady's decision is such an important one. And we say, milady, with the greatest of respect, there's absolutely no case for you to find for the SIU. And like Mr. Harper said, milady, I feel compelled to say this too, that we endorse the SIU in its efforts. In fact, I act for the SIU myself continuously. So we do not mean to criticize the SIU or any of its efforts or to limit them. But truly, milady, this is a case where the law, the trite propositions of law that have been made to support these prospective respondents, and it's in our interest, our client's interest, that they not be joined unnecessarily, milady. It'll only prolong these proceedings unnecessarily. And the two primary grounds submitted to your ladyship is one, no case has been pleaded against any of them. We agree with that, and I point to the distinction between Mtetwa, and that in fact the joint and several liability is sought against Mtetwa and not Mteta. On Mr. Rue's submissions, it would have to have been pleaded against Mteta. But in any case, there is no pleading, which would have to include evidence because these are motion proceedings. That's the first point, milady. And then the second point, milady, that we have to align ourselves with, because it is a correct submission, there is no general cause of action, just like there is no general enrichment cause of action in law. There is no general cause of action under Section 172, milady. And while the powers of a court, having made a finding, such as Section 172 reads, when deciding a constitutional matter within its power, the court must declare that any law or conduct that is inconsistent with the Constitution is invalid, and that's what the SIU seeks in respect of the contract. And in fact, it is our client who doesn't, Mr. Harper correctly pointed out that, well, they don't know. Our client accepts that there were things that were wrong, and in fact, milady, in other words, he goes along with the likelihood of success by the SIU in relation to the contract. And milady, please don't forget this, and I do believe it's in the heads of argument for the SIU. They concede, part of our client's defense, that there are some monies that he may well be entitled to, that may well have been earned. And I believe that's in the heads of argument as well. So, milady, we anticipate that your ladyship will, or that the SIU will be successful on review. That's what we anticipate. I just draw the distinction, Mr. Harper said, for his client, they don't know. Our client knows certain things and has cooperated with the SIU. And then it says, may make an order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration. Now, milady, just and equitable can only be just and equitable if it aligns with all of the trite propositions of law and the law as we understand it in South Africa, starting with pleading a case, putting a party in a position to make inquiries after what that case is if they are not available. Now, those are normally trial action procedures. However, in a motion court, in motion proceedings where relief is sought on affidavit, people in the position of the clients I represent and these other respondents have the benefit of specific and strict rules that have been developed over time that are still upheld constitutionally as to how one works and deals with evidence. And even if one had to uphold the review of the contract, is our submission that the SIU is never going to get a court to go beyond our client's version, especially in the circumstances of one, he's cooperated, and two, it's his information they rely on, and three, they already recognize he may well be entitled to money. They're never going to benefit from the review to the extent that they now propose in relation to these other respondents and money judgments. We just say, milady, properly construed, this is double dipping. It's trite that they can't, this SIU cannot do that. So, milady, their attempt at amendment and at joinder is a stillborn as their convictio argument. The review, it's a different story, entirely different story. So, milady, we just wanted to draw that to your attention. And we thank you, on behalf of my client and myself, I thank you for listening to me. We didn't file opposition or heads, but we accept that you appreciate that our participation is of value. Thank you.
Thank you, Mr. Willis. Yes, Mr. Roux.
Thank you, my lady. I'll start with the Mr. Mthethwa, and quite frankly, I fail to understand the relevance of the argument to you and why Mr. Mthethwa felt that it was the opportune moment to argue the merits of this case. What is, however, telling is, of course, the fact that Mr. Mthethwa desperately wants to persuade you not to join the joining respondents. Secondly, it's not correct to say that we have not amended to make Mr. Mthethwa liable for the full amount. It has been amended. It's not a process. That amendment has taken place, and I've referred you to the case lines record of that. The Cedar Falls, in reply there, just as to a submission made to you, we submit to you that it's not somebody, as was said at one stage, paying money into the Itaba bank it was a payment by one of the main perpetrators of the unlawful scheme, Mr. Mateta. And just in case there's some misunderstanding, if you may make a note, my lady, it's paragraph 43 at 1133, where Mr. Willis says we only talk about Mr. Mateta. Can I just read you what we say there? We say there, the conclusion that Mr. Mateta is a participant in a fraud is reinforced by the fact that the number of payments from the bank accounts of Mateta projects, Bevel's Communications, and Mkokwana events, which on Mr. Mateta's version was under his sole control, bear the hallmarks of the money laundering practices engaged in by the controlling minds of digital buyers. So we refer to all of them. We say he made those payments through his entities, and it was part of that fraudulent scheme. So it's not that we don't say that. So what we say is it's just very difficult to comprehend that there are allegations to say that there was a fraudulent scheme and the proceeds from that fraudulent scheme landed into the hands of people where we say they were concealed payments, not to expose the McKeesey family to say there's no cause of action. That cannot be. In fact, my lady, just to give you some references, we deal with Mateta as a co-conspirator at 1133, paragraph 43, and 1146, paragraph 50, and onwards. Then we deal with undue gratifications in terms of PRECA, and we all know what it means when we say you received an undue gratification. It's not something that you can keep. That's 052/119, paragraphs 23.2 up to 23.6, and we talk about the concealed payments as part of that scheme to the McKeesey family. So that's all there. We also deal with the proceeds of unlawful activities in relation to the joining respondents in 052118, paragraph 23, 052122, paragraph 24 and 25, 052124, paragraph 26, 052124 at paragraph 26. There are many more instances. Just reading in context would tell you it's the same version. That was a fraud. There's proceeds of that fraud, and there was gratification in terms of PRECA, the Corrupt Act. So it's there, and we say this. It's not the time to decide on the merit. One thing that was interesting, and I think it is a statement or a submission made by Mr. Harper as part of his argument before you. And he calls the case of the SIU against his client as a hopeless case. It's not the time to decide if it's a hopeless case. We say it's not, but it's not today whether it's a hopeless case or not. There is a case, there is a course of action. They may not like it. And the course of action has certain consequences, not only in section 172, but inter alia in 172 when it comes to just an equitable remedy. Thank you very much. Yes, that's it. If you would just bear with me. My lady, Mr. Curry correctly raised the point that we make serious allegations against the joining respondent. And in law, they have a right to answer those allegations. And that's another reason why it is important and in law necessary to join them. It's not that we make no allegations. We make serious allegations to say that they receive gratifications in terms of the Act, the Prevention of Corrupt Activities Act. And they have a right to answer it. And if we make those allegations without them party to the proceedings, that would have been a reason to file objections and to come to court. It's the other way around. That's just additional to what we've said. Thank you, my lady.
Thank you, Mr. Roux. We've come to the end of today's proceedings. I'd like to thank all counsels as well as your respective legal teams for your assistance. I am reserving judgment. When it is ready, it will be emailed to your attorneys as well as uploaded on case lines.
Thank you, Milady. Milady, would you like the reference to the case I referred you to in the course of my argument, Buffalo City?
I've got it. Thank you.
Have you? Okay. Thank you very much.
Thank you.
Yes. As Milady pleases.
Thank you. The
Milady.
proceedings
As Milady pleases.
Thank you.